Hey folks, Mark Levin here. Now, before we dive in today's episode, I want to talk about something truly valuable, protecting your financial future with gold. It's called diversification. Now, for that, I only trust Advantage Gold. They're the real deal with 5-star service and a sterling reputation. So give them a call today. Call Advantage Gold at 800-900-8000. Tell them Mark Levin sent you. Trust me, you'll thank yourself in the future. Now let's get to the show. Results may vary. Consult with your financial professional.
He's here. He's here. Now, broadcasting from the underground command post, deep in the bowels of a hidden bunker, somewhere under the brick and steel of a nondescript building, we've once again made contact with our leader, Mark Levin.
Mark Levin here. Our number, 877-381-3811, 877-381-3811. We're going to have some fun today. Well, at least fun as far as I'm concerned. Well, we'll see what you think in a moment, but before we do, the Daily Mail, Trump hush money trial judge, it's a mouthful, Juan Merchan warns parties of incriminating Facebook comment the day before the verdict. By Sarah Ewell Weiss. The judge in Donald Trump's case sent a letter to the ex-president's lawyers and the prosecutors warning of an incriminating social media post that went up before the jury reached its verdict in this historic case, they write. The 12 New York jurors found Trump guilty and blah, 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 blah. But in a letter to Trump's lawyer, Todd Blanche, prosecutor Joshua Steinglass, and the other lawyers in the trial, Judge Juan Merchan brought to their attention a comment posted on the United Court System's public Facebook page. It reads, quote, "My cousin is a juror and says Trump is getting convicted, emoji. Thank you, folks, for all your hard work." See, it was always a setup. Phony jury. Merchan wrote in his letter that the comment was posted on May 29, the day before the jury found Trump guilty from a user, Michael Anderson. It was posted in response to oral arguments in the 4th Department of the Appellate Division unrelated to the trial. The incriminating post raises questions about one of the jurors did in fact discuss the case with others when they were not allowed to. So there's another basis for appeal. Now, you want to have some fun? Let me put it to you this way. I want you to sit back. I want you to relax. Class begins now, and you are now going to know more than any of the legal analysts on television. That's fun, don't you think, Mr. Producer? I don't know. I think it is. All right. If you have kids in the car, tell them, listen carefully. Don't fight in the back. Stick with us. If you're at the dinner table, first we begin at the beginning. And what I'm going to explain to you is an area of the law that most lawyers do not comprehend because they don't practice in this area. But they're more than happy to comment on it. And you might be surprised at my take on some of this. So I open my book, Men in Black. And I turn to page 166. This was my first book ever. And by the way, Donald Trump has raised almost $300 million since the verdict. On December 11, 2000, the Supreme Court held a hearing on the Florida court's latest action. That would be the Florida Supreme Court. On December 12th, by another 5-4 margin, the Supreme Court held that the Florida court had violated the Equal Protection Clause of the U.S. Constitution by ordering statewide manual recounts with different standards in the various counties. See, the court realized that the effort here by the Supreme Court, which was all Democrat, but the chief judge there said, no, this is wrong. But nonetheless, 7 members, 4-3, that they kept allowing recounts on different standards, particularly in the blue counties in South Florida, to get Al Gore a few hundred votes to push him over the edge. On December 12, 2000, by another 5-4 margin, the Supreme Court held that the Florida court had violated the Equal Protection Clause of the U.S. Constitution by ordering statewide manual recounts with different standards in the various counties. In its decision in Bush versus Gore, the Supreme Court stated the following: the right to vote is protected in more than the initial allocation of the franchise. Equal protection applies as well to the manner of its exercise. Having once granted the right to vote on equal terms, the state may not, by later arbitrarily and disparate treatment, value one person's vote over that of another. The recount process and its features here described as inconsistent with the minimum procedures necessary to protect the fundamental right of each voter in the special instance of a statewide recount under the authority of a single state judicial officer. When a court orders a statewide remedy, there must be at least some assurance that the rudimentary requirements of equal treatment and fundamental fairness are satisfied. Remember the Chads fight? Well, the standards were loosened for the Democrat counties. The manual recounts were halted, and the frenzy of litigation initiated by Gore was ended. Gore made his long-delayed concession speech the day following the U.S. Supreme Court's ruling. And what the court did, ladies and gentlemen, is it stayed the Supreme Court's action. It stopped the continuing vote count. It issued its ruling within 48 hours. And at the end, as a result of what they did, the Electoral College votes in Florida went to George W. Bush. It is clear that the 3 judicial originalists on the U.S. Supreme Court, Chief Justice Rehnquist, Justices Antonin Scalia, and Clarence Thomas, 2 great justices are now gone. John Roberts is no Rehnquist. Were not able to assemble a majority on the court on the straightforward question of whether the Florida Supreme Court usurped the authority of the Florida legislature in ordering standardless manual recounts past the federal deadline. Article 2, Section 1, Clause 2 of the Constitution specifically empowers state legislatures to determine how electors are chosen, and we've been through that. The Florida Supreme Court repeated manipulation of state election law procedures and rules supplanted the legislature's authority under the federal Constitution. I've said this over and over again. Those 3 justices wanted that to be the basis of the decision, but they couldn't get 2 more. And so 7 justices, what we call per curiam opinion, unsigned, settled on the Equal Protection Clause of the 14th Amendment. Nevertheless, the actions of the Florida court were so egregious that a majority of the U.S. Supreme Court believed something had to be done to address it. While 5 justices signed on to the U.S. Supreme Court's decision based on Equal Protection Clause violations, 2 additional judges actually embraced the equal protection argument, even though they voted in the minority for other reasons. I believe Rehnquist, Scalia, and Thomas obviously tried to make the best of a bad situation, unable to convince Justices Sandra Day O'Connor and Anthony Kennedy to overturn the Florida Supreme Court on Article 2 grounds. That is, that they defied the power of the state legislature under the federal Constitution. Stay with me. This all makes tons of sense. Still, the best decision would have been no decision. What? The best decision would have been no decision. Stay with me. You got to hear the whole point. While the U.S. Supreme Court's motive was understandable, reining in a lawless Florida Supreme Court, it may well have unleashed future election challenges based on the Equal Protection Clause involving voting machines, voting procedures, the tabulation of votes, the qualification of candidates, and so forth. As I wrote in National Review Online back in December 2000, the question now is, what has the High Court wrought? For example, does a federal cause of action exist if different ballots are used throughout a state? If different methods of voting are used in different counties, or if different methods of voting are used in different localities within a county? Does a federal cause of action exist if older voting machines are used in poor areas and newer machines are used in affluent areas? Where once federal courts were loath to get involved in elections based on lack of standing and or separation of powers, political question doctrines, federal judicial intervention in state and federal elections may now become commonplace. Litigants will attempt to use the courts to overturn the results of elections. And I go on to give some examples. And let's see. There are several significant questions about the 2000 presidential election that are raised frequently but rarely answered. Could the Florida legislature have intervened and chosen the state's presidential electors itself? Page 169, Men in Black. Yes. Article 2, Section 1, Clause 2 of the U.S. Constitution provides that each state shall appoint in such manner as the legislature thereof may direct a number of electors equal to the whole number of senators and representatives, to which the state may be entitled in the Congress, but no senator, representative, or person holding an office of trust or profit under the United States shall be appointed an elector. So the Florida legislature could have, and in fact was preparing, to intervene and name a slate of electors if the Florida Supreme Court continued to interfere with the election. By the way, as a footnote, when I mentioned the possibility that a state had that power in 2020, boy, did I come under attack. You remember that, Mr. Producer? Remember all that? The legislature, which was controlled by the Republican Party in 2000, had absolute authority under the Constitution to choose Florida's members of the Electoral College. This is another reason why Gore's litigation strategy was never going to succeed in winning him the Florida electoral votes that he needed to become president. Was it necessary or appropriate for the U.S. Supreme Court to enter the controversy? I believe the Supreme Court intervened in the 2000 election not to choose a winner, but rather to rein in the Florida Supreme Court, which was intent on allowing county election boards to recount returns under increasingly flawed standards until the desired result had been achieved, a victory for Gore. But it was not necessary for the court to become involved at all. The issue would have been resolved on the explicit language of the Constitution by the Florida state legislature and ultimately the United States Congress. Is there any scenario under which Gore could have won? Both practically and constitutionally, no. There are three basic reasons for this. Ready? First, on November 26, 2000, after Florida's returns had been certified by Katherine Harris, most people didn't know this, we did. Governor Bush sent a certificate of ascertainment, that's what it's called, to the archivist of the United States certifying the election of the Republican slate of electors to the Electoral College as required by federal statute. Once Jeb Bush had done so, no authority, state, federal, legislative, or judicial, could force him to withdraw his certification. You see, ladies and gentlemen, when I was writing about this, we contacted Governor Bush's office and we asked them, or said to them, you know, you have a right to just go ahead and file. And they said, yes, we do, and we did. We said, what? That's right, we did. And we checked it out. And they had. And the media didn't jump on it. Certainly his certification could have been challenged in Congress when the Electoral College votes were counted, but federal law recognizes no other authority who could actually certify Florida's electors or the votes of those electors. I told you, you're going to learn a lot here. Second, once the Electoral College votes were counted in Congress, a challenge of the Florida votes would have required a majority vote in each house to reject Florida's electoral vote, an unlikely scenario as the Republicans controlled the House of Representatives. Even if this hurdle had been jumped, in other words, if there's a conflict, if Gore had gotten the votes in Florida because of what the state Supreme Court was doing, how many times have I told you, we don't have a president until Congress says we have a president? until the electors are counted. And who decides if the votes in the states, that is the Electoral College, are to be counted? Congress. Not a federal prosecutor, not a judge. So even if this hurdle had been jumped, the House would then have chosen the president by a vote of the majority of the state delegations. That's the way it works. Since the Republicans outnumbered Democrats in a majority of the state delegations, the Republicans controlled a majority of the delegations in the House of Representatives. I have no doubt they would have voted to uphold the election of George W. Bush. A very unlikely but technical possible scenario of a Democrat winning would have involved the vice presidency, not the presidency. Had a challenge been made, this would be Lieberman. The Senate, which was split 50-50 along party lines, would have selected the vice president by the vote of individual senators. Since Gore was still serving as vice president and therefore president of the Senate, he could have cast the tie-breaking vote for Joe Lieberman. In other words, George Bush was always going to be president, no matter what the Florida Supreme Court did or the U.S. Supreme Court, because Congress has the final say. And it would have been decided by the majority of the state delegations in the House, 27 of which were Republican. The Senate would decide the vice president. The Senate was 50-50. Al Gore was still vice president, hence the president of the Senate. So technically you could have had Bush as president and Lieberman as vice president. But that's how the system works. Don't go away. I've got a ton more because it's relevant to what's going on now. I'll be right back.
Mark Levin.
You know, folks, China, Russia, Iran, they're all on the move. Right here in the U.S., you've got inflation, you have open borders, and, of course, an election year. Oh, and we just crossed over $34 trillion in debt with no signs of slowing down. It's time to wake up, folks. There's a lot at risk, possibly even your retirement account. The time to protect yourself is before a crisis, not after. Advantage Gold, the gold and silver company I recommend to help Americans. Well, they'll help you prepare now for times just like these. Call them at 800-900-8000 today. Get their free 2024 gold and silver kit. Plus, tell them I sent you, and they'll give you a special Mark Levin discount worth up to $1,300 if you qualify. Call Advantage Gold today. Here's the number, 800-900-8000. Plus, see if you qualify to get your special discount worth up to $1,300 today, 800-900-8000. Performance may vary. Past performance is not necessarily indicative of future results. You should always consult your financial and tax professional. The body, this is the problem. The media and others don't comprehend. The body that chooses the president, when it's all said and done, is Congress. That's the Electoral College process. Part of the process is you vote. You vote for electors who support a given candidate. Those electors then meet and they vote. When that's done, the results are sent to typically the Secretary of State. Secretary of State then signs off on them, sends them to the governor, and the governor then signs off and sends it to the archivist of the United States. On January 6th of the relevant year, sends the results to Congress to vote on whether to accept them as presented. It's not over until that vote occurs. I'll be right back. You know, folks, we've got an awful lot swirling around this country, both internally and externally. We've got wars going on in all parts of the world. We've got riots effectively going on in our colleges and universities. We have inflation through the roof. It's an election year to boot. All these problems are often huge tailwinds for gold, which is why gold is at all-time highs, looking like it's going to go higher. And when it comes to gold, I only trust my friends at Advantage Gold. They help Americans just like you protect your retirement accounts and help safeguard your wealth through diversification. So call them right now. 800-900-8000. Get their free 2024 gold and silver kit plus a special Mark Levin discount worth up to $1,300 if you qualify. Call Advantage Gold right now. 800-900-8000. See if you qualify to get your special Mark Levin discount worth up to $1,300 today. Performance may vary. Past performance is not necessarily indicative of future results. You should always consult your financial and tax professional.
Mark Levin, the research arm of conservative media. Call in now, 877-381-3811.
Now, Mark, I'm completely confused. You've been saying the Supreme Court should take up a direct appeal from Donald Trump based on Bush versus Gore. Here's the situation. Bush versus Gore was a case that took place after the campaigning was over. They were counting the votes that were cast. The court took up the case, stopped the Supreme Court, put a stay on, ruled that the court had violated the Equal Protection Clause of the 14th Amendment, applies to the states, the 5th Amendment to the 14th Amendment. And hence, George Bush won. The Senate was 50-50. The Republicans had control of the House. There was no way George Bush would lose. The situation I'm talking about now is more egregious than what was occurring under Bush versus Gore. The problem with the case in New York is that the election is ongoing. We're right in the middle of the election. What this trial court did was assume powers it doesn't have and violate federal jurisdiction, federal constitutional law in a federal presidential election, and assumed authority over federal election laws. The Florida Supreme Court doesn't even come close to doing that. And we're in the middle of an election where nobody's cast a vote yet. So we have a situation, we have one candidate, a Democrat, who can run for office unfettered, say whatever he wants about whatever he wants. Nobody can tell him whether he campaigns or he can't campaign. No threat of imprisonment or an ankle bracelet or a probation officer telling him to inform me every time he lit. None of that. And, of course, the purpose of the litigation was to do exactly this. And in pursuit of that goal, the acting state judge, under color of New York State authority, violated the First Amendment to the Constitution, free speech, and non-disclosure agreement is free speech. That's the bottom line. In addition to the unconstitutional gagging, violated the Fifth Amendment to the Constitution that applies to the states under the 14th Amendment. What am I talking about? Due process. And equal protection. Due process, so many cases of violations of due process. You don't get notice of what you're being charged with. And a violation of the Sixth Amendment. You have a right to competent counsel, but counsel could not be competent when they were hiding witnesses, when the judge was cutting them off in the middle of questioning. And I could go on with the facts, but we know the facts. And, of course, the timing of the case after 7 years, pretending to breathe life back into misdemeanor business statutes that had already run the statute of limitations by an ambiguous, nebulous claim to federal law. If I were to produce a movie of the most egregious violations, one after another, after another, after another, of a defendant, with national and international consequences, it would be the case that just took place. And the problem is this is ongoing. Trump has a sentencing hearing 4 days before the convention. Why? Why is that the date for it? It's obvious. So now what do? Do we wait for Congress? You can't wait for Congress in this instance. We're not talking about counting the votes. Are we, Mr. Producer? Nobody's cast a vote, have they? So now we're talking about interfering with a campaign for President of the United States. So let's first talk about federal jurisdiction. We call it federal preemption. That is, the federal government, when it comes to the federal election law, the enforcement of the federal election law, has plenary power. There is no state power. None. And the federal judiciary, the Supreme Court, has a responsibility, a duty, and it would be a dereliction of duty if it doesn't act, to preserve federal authority under our Constitution, federal jurisdiction, and the federal Constitution. So you have expressed federal preemption, you have implied federal preemption, you have the ability of the federal government, that is the courts, to prevent obstacles to preemption. You have all those in play here, all of them. All of them. Let me put it simply. A state court cannot regulate Congress, that is, a federal campaign law. It doesn't have the power to do that. A state court cannot usurp or eviscerate federally or constitutionally established laws or rights, due process rights, free speech rights, equal protection rights. It doesn't have the authority to do that. Federal courts, starting with the Supreme Court, have intervened in state actions and claimed federal jurisdiction using the Supremacy Clause, the Commerce Clause, the Necessary and Proper Clause. And it doesn't even have to use any of those clauses in this case. It's been applied to state laws involving housing, civil rights, zoning, religion, health. At its core, the judiciary is supposed to protect, when it comes to jurisdiction, federal jurisdiction. That is, Congress's intent. To cut to the chase. When it comes to regulating federal elections, especially a presidential election, Congress has exclusive plenary power, period. No locality, no county, no state has authority over federal election law or presidential elections. I don't need to get into the voting issue and setting voting rules. We're not talking about that. We're talking about a power grab like we've never seen in American history, ever, by an acting state judge and a Soros prosecutor. We've never seen this before. So why do I mention Bush versus Gore? Because Bush versus Gore demonstrates that the Supreme Court will step in if it believes that the federal election process, that is, the election of a president of the United States, is being damaged usurped, tainted by a rogue authority, whether it's the Florida Supreme Court or an acting state judge and a Soros prosecutor in a courtroom in Manhattan. Does that guarantee that they'll get involved? Of course it doesn't guarantee. There is no guarantee. But Bush versus Gore tells us that it's not a fantasy, it's not a fiction. They stepped in when they actually didn't have to. But in this case, they must. Or the entire election could be tainted. And this is an ongoing taint. It's an ongoing interference. It's an ongoing violation of multiple constitutional issues and jurisdiction. So how do you get the case to the Supreme Court? See, in our system, justices can't sit around and say, you see what this judge did? We sure did. All right. Do we have enough votes here to take up this case? We sure do. It doesn't work that way. A court can't bring a case to itself. It can in Israel, why that court is totally out of control. But it cannot in the United States. So what do? First of all, you got to research the topic. You can't just go on TV and shoot out of your butt. Or write columns and shoot out of your nose. I can't give you all the research I have. It's stacked up right here. These are things I've studied in the past. I studied it in 2000. I dusted them off. But this one is somewhat helpful. When you look at the research, I've looked at SMU, Southern Methodist University, the Dedman School of Law. And way back in 1969, January, a gentleman by the name of Griffin B. Bell, who would become the Attorney General of the United States under Jimmy Carter. And he was quite a good Attorney General, actually, as Democrats go. He was fairly conservative. Certainly wasn't a kook. And there's this article that's written, The Federal Appellate Courts and the All Writs Act. You with me? You with me, Mr. Producer? And we're talking about what I've called common law writs on Fox, on this program, and on my Blaze show. Common law writs. What's common law? Common law are common practices that apply to the law that have taken place in the past, like in Britain and so forth, in which the United States, in many respects, has referenced or used, including to give direction on what kind of statutes we might want to pass. They're called common law writs. And there's a law called the All Writs Act. And he wrote, while the basis for general judicial supervision over inferior courts through extraordinary or preemptory writs can be found in early common law, the All Writs Act, a law, is a direct descendant of the Judiciary Act of 1789. You see, under our Constitution, the only court that's created is the Supreme Court. But the number of justices is determined by Congress. All the appellate courts, the district courts, created by Congress. The number of courts, created by Congress. The number of judges on the circuit courts, created by Congress. Each circuit court, what states they have jurisdiction over, created by Congress. See what I'm saying? Congress creates the judiciary but for the Supreme Court. Section 14 of the Act granted federal courts the power to issue extraordinary writs in aid of their respective jurisdiction. In aid of their jurisdiction. And while it is clear that the All Writs Act authorizes the issuance of the traditional common law writs of mandamus and prohibition, don't worry about that right now. The phrase all writs also encompasses common law certiorari, injunctions, subpoenas, so forth, writs of habeas corpus, and all other writs necessary or appropriate in aid of jurisdiction. Just think of it as a writ. Now, you seek a writ when you go to the Supreme Court, and they decide whether or not to hear your case. They will issue a writ of certiorari, a writ of prohibition, a writ of mandamus. It doesn't matter right now. As he points out, more than 50 years ago, Choosing the correct writ to obtain the desired relief is no longer necessary in federal courts. Different writs may be sought alternatively or cumulatively. The choice is now unimportant. The subtle distinctions among the various writs have no effect on the relative usefulness as vehicles for interlocutory review. What's an interlocutory review? That means the case isn't over or the appeals aren't over. Interlocutory. But there's a situation of such urgency that needs to be cleared up or clarified. And you file an appeal that would typically not be ripe, but it's called an interlocutory appeal to the next level court. Okay? Now, I'm going to take a break. We're going to continue this in the next segment and probably the next hour. You got to hear me go through this process so we can get to the bottom line. Is this helpful, Mr. Producer? I am conveying to you, I am providing to you in 1 hour's time, an hour and a half's time, 200 years of American jurisprudence, decades of study and analysis, in as plain of English as I know how. So even the backbenchers might understand it. I'll be right back.
Mark Levin.
All over the world, our enemies are on the move. And in our own country, same thing. Things are tough between rising prices, election issues, a $34 trillion debt. But folks, there is good news. If you're smart, you can use these problems to your advantage. By making the right choices right now, you can keep your retirement money safe and even make more money in this climate. That's where Advantage Gold comes in. They're experts in helping Americans protect their savings with gold and silver. It's called diversification. Call Advantage Gold today, 800-900-8000. They'll send you a free 2024 gold and silver kit that tells you how to keep your money safe when things are bad. Tell them I sent you, and you may qualify for a special Mark Levin discount worth up to $1,300. Call Advantage Gold at 800-900-8000, 800-900-8000. See if you qualify for that special discount worth up to $1,300. That's 800-900-8000. Performance may vary. Past performance is not necessarily indicative of future results. You should always consult your financial and tax professionals. Now, I only have about 40 seconds left, so I brought you this far. Now we're going to go to the closing. So stay with me. I provided you with a lot of information. I understand that. You can always go back and listen to the show again. We have it on marklevinshow.com within a couple hours of the end of the program. In fact, if you can share it with your members of Congress just so they can educate themselves, wouldn't be a bad idea. But that said, just a little bit more. I'll close the circle. I'll be right back. This segment of the podcast is exclusively sponsored by Pure Talk. Pure Talk offers great coverage and can save your family money on your wireless bill every single month. Go to puretalk.com to find the plan that's right for you. Thank you again for listening, and thank you so much for this sponsorship, Pure Talk.
He's here. He's here. Now, broadcasting from the underground command post, deep in the bowels of a hidden bunker, somewhere under the brick and steel of a nondescript building, we've once again made contact with our leader, Mark Levin.
Hello, America. Mark Levin here on this busy Friday. Our number is 877-381-3811. Hello. 877-381-3811. Before I finish what I started, listeners of this program, you know, I've told you that Joe Biden is going to pardon Hunter Biden. I've also told you that Joe Biden will pardon Hunter Biden should he be convicted after the election. Now, maybe we should transcribe everything we say, Mr. Producer, and post it, although we don't have anybody to do that. I'm not intending to do that, because it seems like the written word is remembered more than the spoken word. I've also told you something else, that the Iranians may already have may already have the ability to build a nuclear weapon, but they're waiting till after the election to announce it. Because my theory that I've explained here several months ago is this, and I think it's more of a reality. There's no real solid explanation for why Joe Biden never calls out the Iranian regime, doesn't attack them when they kill 3 Americans, lobbies against sanctioning them when Britain, France, and Germany want to sanction them, provides them with $100 billion directly and indirectly to build up their war machine and to fund their nuclear program. Unless it's an exchange for helping them win election to the presidency by not announcing that they have nuclear capabilities, the ability to build a nuclear weapon on Joe Biden's watch. That is a game changer. It's not to say they won't. But so far they haven't. And Joe Biden's behavior is always about self-empowerment. It's always about self-enrichment. It's never about the country. That's why the border is wide open. He thinks it's going to help his party take back the House one day when the census is taken, and down the road all these illegal aliens will have children, and those children become birthright citizens. Let's not get into that now. You know I don't believe that's correct, but that's what's happening. Joe Biden will pardon Hunter Biden if Biden's convicted, and he should be. I mean, it's such an open and shut case. It's a real trial with real due process and equal protection, with real evidence, real witnesses, a real judge. But he'll wait till after the election. Win, lose, or draw. And his behavior toward the Iranians, funding them, special pleader for them, lobbying against sanctioning them, and all the rest of it, attacking Israel relentlessly, undermining Benjamin Netanyahu relentlessly. It's more than he's an anti-Semite, which of course he is, and always has been. He knows how to cover his tracks. He says one thing and does another. But my point is, he's getting something in return. It is a quid pro quo, and that is they're not going to have a breakout until after the election. Now, if they have a breakout before the election, that just means they're not worried about it. That Joe Biden's not going to do a damn thing anyway. And they'll go back on their arrangement. It's Joe Biden, I would argue, who is doing everything possible to prevent the Iranians from announcing or acknowledging that they have the ability now to make nuclear weapons and that they're in fact going to do it. I hope I'm making myself clear on both of these points. Very clear, because it's very important. All right, let's get back. I can't go over the territory you already covered. But let me just add this one last legal point. As Griffin Bell wrote in his 1969 law review piece, Southern Methodist University, the Dedman School of Law back then, January 1969, the jurisdictional prerequisite. By the way, really smart lawyers out there are going to have a question, and I'll get to that in a minute. The jurisdictional prerequisite for application of the All Writs Act is simply the writ be necessary or appropriate in aid of the jurisdiction of the issuing court. In other words, they can pick whatever they want. It's just a mechanism for the court to act. And he points out that there's a writ of prohibition, a writ of mandamus, writ of habeas corpus. You can actually use a writ of habeas corpus in 2 different ways, information that we don't need to get into. It doesn't matter. So there might be some hotshot lawyer out there that says, look, I never really understood any of this, but what you're saying doesn't make sense to me. What do you mean? This All Writs Act? Yes. It's talking about taking a case from a federal district court in an interlocutory appealing them to a federal circuit court. It's not talking about a state court. and taking an appeal from a state court to the U.S. Supreme Court. It's not talking about that. So why are you citing the All Writs Act, which was basically a function of the Judiciary Act of 1789? And I would say to that hotshot lawyer, you haven't been paying attention, have you? Have you? Common law writs don't just apply within the federal structure. In fact, we have case after case where common law writs have been used, sometimes effectively, outside of the federal chain of courts and appellate processes. The All Writs Act explains how it's done within the federal judicial system. It provides a statutory path to use a non-statutory writ. Fine. But a common law writ is not limited by the All Writs Act. I'm referring to it to show the audience that it has been done within the federal court system, but it's also been done outside the federal court system. A writ of mandamus, a writ of prohibition, a writ of habeas corpus. In this piece, Griffin Bell points out that the court has said it's to be used for extraordinary circumstances. But he also points out correctly that is a phrase that has no meaning. They don't even define what it means other than using other ambiguous phrases. So what is all this, Mark? We can get to the bottom of this. Okay, it's this. A court may want to get involved in a case to bring order to disorder, to bring law to lawlessness, to help save the republic, the election system, federal jurisdiction. It just needs somebody with standing to file a petition through one of these avenues so it can look at the case and decide whether to take it. And then it'll decide what doctrine it may use to rule on it. There is no black letter law. This is the exception to the rule, but it is an exception that does exist. This is why Arthur Ferguson, a friend of mine, practicing lawyer, former clerk to the late Chief Justice Warren Burger, former Special Assistant United States Attorney. This is why he and I came up with this argument, this explanation. He told me when he was a clerk, he actually had to deal with some of these writs. And he said, and I would tangle with this for hours, in some case days, given the unusual nature of it. But it exists. It's real. It's tangible in the law. If I had to guess, 99.99% of practicing lawyers in this country have never used it. That doesn't mean it's not a tool. I guarantee you there's not a former federal prosecutor, maybe there's one or two, who've ever even, not just used it, ever heard about it. Because that's not their lane. That's not their lane. In fact, if a common law writ's to be raised, it would be raised by defense counsel in most cases, and that's how they come up from time to time, death penalty cases and so forth. And what I'm trying to explain is there's nothing that excludes or prevents President Trump's lawyers from using a common law writ like a writ of prohibition. What is a writ of prohibition? Let me put that one as simply as I know how. Writ of prohibition restrains a body exercising public power, that would be the state court, from exceeding its powers or usurping jurisdiction which it does not have. This is right in the bullseye. And I would argue, for those hotshot lawyers out there, it's even more necessary. It's compelled even more when you're talking about a non-federal court interfering with the jurisdiction of the federal courts, and especially the Supreme Court. So rather than being an argument against using it, it's an argument not only for using it, but explaining that these writs are more important now than they've ever been. So outrageous and extraordinary is and was the conduct of this prosecutor and this judge in New York State involving a presidential election, involving federal campaign law, involving the violation not just of the U.S. Constitution, but core elements of the Bill of Rights of the U.S. Constitution. We've never seen anything like this before. And if it's left unaddressed, this system will completely unravel until it is addressed. It's not going to stop in New York. California will be next. Illinois will be next. Rhode Island will be next. What's to stop one of 2,500 district attorneys from acting like this? And state judges from acting like this. We've already seen what they're capable of. We saw it in Colorado when that court system was trying to throw Donald Trump off the ballot with an outrageous interpretation of the 14th Amendment. We saw it in Maine. And you're going to see a hell of a lot more of it. This is an ongoing constitutional crisis. It is ongoing. You've heard the legal analysts with different backgrounds than mine telling you they've never seen anything like this before. Good. That helps. Telling you the laundry list of violations that took place in that courtroom. Good, that helps. But then they tell you, well, we're stuck. The country's done. The election is interfered with. You have to go through the New York appellate process. It's a lumbering process. The next line of appellate judges, 20 out of 21, they're Democrats. They've been contributing to Democrats. They're appointed by Democrats. They're very liberal. Trump probably doesn't have a better shot there. The next level, the highest court, might be okay. But it won't happen until after the election, so woe is me. No, not woe is me. And just because you, Mr. Hotshot Attorney, don't understand this process or have a very nebulous understanding of this process doesn't mean it's so. Doesn't mean the Supreme Court will take the case. I had one person say to me, well, what if they don't take it? Then what does that tell us? Then people will be very critical. What are you talking about? This isn't about politics. This is about the Constitution and the Republic. So who cares what the grifters on TV have to say? See, I told you so? And they'll say that to me more than anyone. See, Mark, you never should have done it. It wouldn't have worked. No, wrong. Wrong. I'm right. And if the justices are too cowardly and don't want to take it up, they'll be kicking the can down the road to 4 years from now, when another district attorney will target another Republican presidential candidate under some phony interpretation of some phony law. Does it get any phonier than this? There was no law. Does it get any worse than this? The state law had never been used this way. The state law wasn't violated. The state law was dead. They refer to some nebulous federal campaign law. The defendant doesn't even know what he's really charged with. You got a corrupt jury, we now know. A corrupt judge, a corrupt... Does it get any worse than this? So if the court says no, the court says no. But you're giving the court the opportunity to say yes. And so I circle back to Bush v. Gore, where they said yes in a matter that was not even as horrendous, not even close to being as horrendous is what's taken place in New York. I'll be right back.
Mark Levin.
Did you know one of the largest U.S. flags in the state of Georgia stands proudly in Pure Talk's parking lot? To honor that flag, Pure Talk is supporting America's Warrior Partnership in their mission to prevent veteran suicide. For our servicemen and women, the transition to civilian life can be very difficult, especially now. Access to housing, employment, and even their earned VA benefits can be very difficult. That's where America Warriors Partnership steps in by providing real support where and when our vets need it most. And you can help this noble cause when you switch to Pure Talk's 5G service and support this great charity. Through Flag Day, they'll match every dollar donated up to $50,000. Choose a wireless company that shares your values and puts you on America's most dependable 5G network for just $20 a month. Go to puretalk.com/Levin. That's puretalk.com/LEVIN to make the switch. That's puretalk.com/Levin for superior cell phone service that's half the price of Verizon, AT&T, or T-Mobile, and to help Pure Talk with vets in need. The media is so stinkingly corrupt. The Arizona case. Mark Meadows pleads guilty to the fake electors charges in Arizona. Fake electors charges? What the hell is that? Well, they created a second set of electors. They knew better to throw in to the National Archives for Congress to see. That's not illegal. Well, they knew Trump. I said, that's not illegal. Once again, you start from the premise that's in the Constitution, which is Congress makes the decision who president is and what electoral college votes they count. Ask the Marxists, Jamie Raskin. Ask him. He's been on the floor of the House objecting all the time to the count of electors from this state or that state if they elect a Republican. There's no such thing as fake electors, a crime of promoting fake electors. And yet now we've criminalized it. We've even criminalized Donald Trump saying that the election is corrupt. Now that's obstruction under an Enron application of obstruction. So it's like 10 degrees away from the law. But it doesn't matter. Because you're dealing with truly low IQ, stupid people who we call journalists. You're dealing with truly low IQ, radical ideologues who we call journalists. That's why you got to listen to me to explain the Constitution and the law and elections and all the rest. You're not going to get it from these a-holes, that's for sure. I've got a lot more when we return. I'll be right back. Did you know one of the largest U.S. flags in the state of Georgia stands proudly in Pure Talk's parking lot? To honor that flag, Pure Talk is supporting America's Warrior Partnership in their mission to prevent veteran suicide. For our servicemen and women, the transition to civilian life can be very difficult, especially now. Access to housing, employment, and even their earned VA benefits can be very difficult. That's where America Warriors Partnership steps in by providing real support where and when our vets need it most. And you can help this noble cause when you switch to Pure Talk's 5G service and support this great charity. Through Flag Day, they'll match every dollar donated up to $50,000. Choose a wireless company that shares your values and puts you on America's most dependable 5G network for just $20 a month. Go to puretalk.com/Levin. That's puretalk.com/LEVIN to make the switch. That's puretalk.com/Levin for superior cell phone service that's half the price of Verizon, AT&T, or T-Mobile, and to help Pure Talk with vets in need.
Mark Levin, making conservatism great again. Dial in now, 877-381-3811.
You know, something's been bothering me. This Caitlin Clark, the greatest female college basketball player in the history of college female basketball. After 3 years of college, not even 4 years. By all accounts, she has a fantastic personality. She's very mature. She's very friendly, engaging. She doesn't make outrageous comments about other players, take on these huge social issues. She just does what she does. And the American people have taken a big liking to her, from all backgrounds and all races. And her early entrance in the WNBA has really sparked that league and has increased revenue across the board, has caused the league to do things to help the ladies in that sport that they otherwise couldn't afford to do or wouldn't do. But I have to tell you something. As a pedestrian, I'm no expert on it, watching what's been happening to her, I'm disgusted by it. So first, I want to say that Stephen A. Smith, Shannon Sharp, Charles Barkley, others who are far more knowledgeable about sports than I, kudos to them. When she was slammed, blindsided, knocked to the ground, could have had a career-ending injury on her knee, on her hip, God knows what, her Achilles. They were infuriated by it. But I want to go much further. The attacks on her are racial. I would say this if it was a mostly white league picking on a black athlete. I don't like bullies. I don't give a damn who they are, what color they are, what background they are, how big they are, whether they have 3 eyes and 2 noses. I don't care. I've never liked bullies. I remember when I was a kid, 4th, 5th, 6th grade. I don't remember that, but one of those grades. And I was a safety. Remember safeties, Mr. Producer? Do we even have safeties anymore? I don't even know. I'd get up at 5:45 in the morning. What was I, 12 years old? I'd walk to the corner with the belt around me, and, you know, you help the kids. You're trained what to do and so forth. But there was a little group of punks. And they would say nasty things to me all the time because I was wearing the safety belt. And I said to my father, who was a very intelligent man, a very kind man, a very decent man, but tough, Dad, what should I do? You can't do this today. You'll go to prison for the rest of your life as a 12-year-old. You said you pick out the leader of the gang. It wasn't a gang with knives and guns. They're kids. And if he touches you or gets in your face, you hit him as hard as you can in the stomach. And that's what I did. Again, I don't recommend this. It's a different time. I'm 66 years old. Today, you'd go to Sing Sing. All that comes to mind when I watch what happens to this woman. Why is she being treated this way? Jealousy? And then as the days go on, I hear all this racist stuff from some of the players. Well, I'm going to tell you what. Just like when the football players were taking the knee, and you and I stopped watching, stopped buying, stopped going, I'm going to tell you what. If this keeps up, I'm going to lead a national boycott right behind this microphone against the WNBA. Not because she's white, because I'm sick and tired of this racist crap. I'm sick and tired of it. Whoever practices it. Whomever practices it. They need us, these leagues. We don't need them. There's plenty of options. There's plenty of alternatives. Football is probably my favorite sport. Actually, my favorite sport is the UFC. If you call it a sport, I think we do. But football. That was fine for a couple of years. I didn't bother with it. I didn't bother with it. And as the 3 gentlemen I mentioned have said, they ought to be riding this gravy train. They ought to be pleased about it. Just do your thing. Be the best basketball professional you possibly can be. Stop focusing on her. You don't need to pick on her. You certainly don't need to physically harm her. Again, I would say that about anyone and anything if I know about it. Who's that little squirt sportscaster, the left-wing kook, Bob? What's his name? Costa. He's so perverse the way this guy thinks. I don't know the names. I don't follow the sport. I've already said that. I followed what I saw and what I heard. But I'm not big on the WNBA to begin with. I don't care. But some people are, and more people are. But I'm big on confronting bullies and racism. This I don't like. Period. But he says, well, there's hypocrisy here. I read this piece to you because apparently another player, a black player, was attacked or physically pushed and what have you by the same player or another player. But there were two black athletes. And he said, I don't remember all the noise back then. You know why you don't remember all the noise back then, Bob? Because most of us weren't following the WNBA. That's why, Bob. Most of us never heard of these people and never watched them. I'm not saying people don't. I'm not saying a lot of people don't. I'm saying most of us in this audience, we don't. So does that make us racist? No. I just don't care to watch it. Excuse me. I don't watch bocce either. Does that mean I'm anti-Italian and anti-white, Mr. Producer? No, I don't like it. But if other people like it, great. As a kid, I used to watch bowling. I don't watch bowling anymore. What does that mean? I don't know what it means. Who cares? Who cares? But I know what I saw here, and I heard what people were saying in the sport. So maybe they need a little help to get things straight over there. So I'm not going to keep watching, but if other events take place, and we'll know if we watch really the finest sports show on television, First Take. I'm quite serious about this. This Stephen A. Smith is a great broadcaster. No offense, I don't watch the other ones. I mean, maybe I'll catch him by accident or something like that. There's a ball guy late at night. I can't remember his name or this one, that one. But, you know, it is what it is. I call him as I see him. I don't always agree with him, by the way. He's another Trump hater. He would disagree with the way I explain that, but that's all right. He's not going to vote for Biden, so that helps. How do I know? I don't know, but that's my impression. You know, if I can get as many people as possible not to vote for Biden, that's okay. If they're not going to vote for Trump anyway. But he's an independent thinker. I like independent thinkers. In fact, I am an independent thinker. I think for myself. Okay. Here's a montage from 2020. On the Biden laptop, where Biden, Blinken, and others committed a federal offense for which they should be indicted, according to the precedent, if it's left untouched, of Marchand and Bragg in the Manhattan case. Because this letter was a lie, it was drafted at the direction and knowledge of Joe Biden and Antony Blinken, and it was carried out. We have testimony under oath, under penalty of perjury in Congress, by a former deputy CIA chief. And so this is a crime waiting to be charged. I'm sorry. I didn't create this scenario. They did. And let's listen to them. We have them all on record. We have them all on record in the media. Media now citing the laptop, which is being used in federal court all week. Texts and emails. The FBI says it's the real deal. It's the real deal. It's real. The authenticity of the laptop and its contents are not in dispute, despite the fact that social media, the New York Slimes, the Washington Compost, Politico, and the rest of the garbage that pretends to be American media, that is, the American Al Jazeera media, despite their lies to the American people, right through the general election, and despite Joe Biden, the worst of the friggin' liars, using his plant of that letter with these 51 stooges during the last debate with Trump when Trump brought up the laptop. Here's a montage from 2020, the Biden intelligence officials and the media, that the laptop was disinformation. This goes on for 20 minutes, Mr. Producer. Well, we won't play it all, but it goes on for 20 minutes. Let's get a taste, shall we? Cut one, go.
And tonight, the Trump campaign is accusing Twitter and Facebook of censorship after the social media companies blocked the spread of an unverified story about former Vice President Joe Biden's son and a laptop allegedly full of his old emails. It's a story raising concerns about whether it's real or just designed to sow confusion in the final weeks of the election.
Experts say it has all the hallmarks of information laundering.
This looks like your classic disinformation campaign.
Eric O'Neill is a former FBI operative.
Steal the information with a cyber attack, get the emails from Hunter Biden's account, and then put them on these laptops that are left at a repair store. And that's how the information is now laundered into the public.
Sure.
Who do you think is behind this?
Well, the Russians would be my number one guess.
Social media outlets were quick to limit the spread of the story. Twitter briefly suspending the accounts of the Trump campaign and White House press secretary after they tried to share it.
Twitter and Facebook have limited the distribution of that Hunter Biden story. And last night, Twitter appeared to suspend the Twitter account of White House press secretary Kayleigh McEnany when she tried to share that story.
Damn. You know a story is shady when Facebook is saying, whoa. Maybe people shouldn't see this.
For a long time, Giuliani has been openly working to dig up dirt and promote disinformation on the Bidens. And now the Washington Post is also reporting that the intelligence community was so concerned that the Russians were using Giuliani to feed Russian disinformation to the president that they warned...
All right, let's slow down. We'll start it up a little later, but I just want to make a point here. You see how the Democrats work with the media, because the media are Democrats. You see how the media work with the Democrats? This is third world banana republic tyranny. They've been caught on this, but they were caught after the election. They do this every day. They do this all the time. Like the San Alito flags. They work hand in hand with each other. I'll be right back.
Mark Levin.
Did you know one of the largest U.S. flags in the state of Georgia stands proudly in Pure Talk's parking lot? To honor that flag, Pure Talk is supporting America's Warrior Partnership in their mission to prevent veteran suicide. For our servicemen and women, the transition to civilian life can be very difficult, especially now. Access to housing, employment, and even their earned VA benefits can be very difficult. That's where America Warriors Partnership steps in by providing real support where and when our vets need it most. And you can help this noble cause when you switch to Pure Talk's 5G service and support this great charity. Through Flag Day, they'll match every dollar donated up to $50,000. Choose a wireless company that shares your values and puts you on America's most dependable 5G network for just $20 a month. Go to puretalk.com/Levin. That's puretalk.com/LEVIN to make the switch. That's puretalk.com/Levin for superior cell phone service. That's half the price of Verizon, AT&T, or T-Mobile, and to help Pure Talk with vets in need. They saw the other day that under Biden, the rich are getting richer and the non-rich are getting poor. He talks about bottom up, middle out, rich pay their fair share. This guy's a fraud. He's a fraud from the bottom up, the middle out, and the top down. I'll be right back.
He's here. Now, broadcasting from the underground command post, deep in the bowels of a hidden bunker, somewhere under the brick and steel of a nondescript building, we've once again made contact with our leader, Mark Levin.
Hello, America. Mark Levin here. Our number, 877-381-3811. 877-381-3811. The full-throated anti-Semitism of the Democrats continues to be on display as Nancy Pelosi and Jim Himes of Connecticut, other reprobates, miscreants, and malcontents say that the idea that Benjamin Netanyahu will speak to Congress is awful. It's horrendous. The Democrats are character assassins, much like Mao was, Stalin was, much like Un is, much like the Islamists. And they learned this from Lenin. And Saul Alinsky picked up on it, and he Americanized it. That's where Hillary Clinton got it, and Obama got it, and the rest of them. And so they target individuals, and then they try to character assassinate them. Alito, Thomas, Gorsuch, Bork, Trump. The list is a long one. Netanyahu. You have countries out there with genocidal maniacs who've slaughtered their own citizens, who slaughtered people in other countries. The Democrats don't say a damn thing. They don't even know the names of these people. But Benjamin Netanyahu is the only world leader they treat like this. The only one. Even the ones aiming nuclear missiles at us, they don't talk about like this. It's sickening. And so, here we have Nancy Pelosi on CNN, and Dana Bash, who's Jewish, she brings on these anti-Semites because they're Democrats. She brings on Bernie Sanders because he's a Marxist. She knows what they're going to say, and she brings them on to say it. A self-hater. Like Jake Tapper. It's a sad fact. Here we go. Cut 14, go.
If you were still Speaker, would you have invited him?
So what kind of a question is this? She's not Speaker, and she didn't invite him. And she knows she wouldn't have invited him. Because the Democrat Party is filled now with so many Jew-hating, American-hating Marxists and Islamists. Just like Biden, they have no intention of controlling their base. They're seeking to expand it. So what kind of question is this from an idiot? An idiot. Dana Bash. Go ahead.
No, absolutely not. Absolutely not. I think that I think this is wrong. Frankly, I didn't approve of his being invited the last time, but the Speaker just on his own invited him without consulting with the rest of the leadership. And he came and he criticized President Obama for the masterful work that he had done.
There you go. I don't need to hear anymore. See that? He criticized our hero, our God, Barack Obama. Actually, he didn't criticize him. He went out of his way not to criticize him, certainly not by name, but he's defending his country against the Islamo-Nazi regime in Iran that wants to get nukes and keeps threatening to blow the country off the face of the earth. Gee, how dare he speak to Congress? Then we have somebody named Jim Himes, Himes, Democrat, Connecticut. He's on MSNBC, so you can see they're all spreading out. CNN, MSNBC, the same phony news organizations that were more than happy to deny the laptop and to spew the Biden-Blinken propaganda. And again, we salute the New York Post. The New York Post, in the middle of this tornado, stood firm. Miranda Devine, and yes, Rudy Giuliani, who they're destroying. Go ahead.
You've called Netanyahu speaking before Congress a terrible idea, but now that the date is officially set, what do you think the implications are? And you will go, correct?
So what kind of question is that from Chris Jansen at MSNBC? What kind of setup questions are these? Well, they're carrying the ball for Biden and Hamas and Iran. The deal has been cut. The deal has been cut. Pretty sickening, really. And they'll keep inviting people on to say the same thing. And then when he speaks, they'll attack him. When he's done, they'll attack him. And this is the party that's intervening in the election in Israel, trying to get their boy Gantz elected, because he is a lapdog. He's actually a very dumb guy. So they want him in. They want him in. And that's how it works. Now, Biden believes that what took place in New York was a very fair trial. But he would, because he was behind it. Not every aspect of it. He didn't pick the judge. He didn't pick the prosecutor. But the signals were sent as number 3 at the Department of Justice. You know, George Stephanopoulos, such a clown, such a buffoon. How did he get such a big job with all that money at ABC News? He's not a journalist, because they're all Democrats. And so he's put out the word to his fellow Democrats in the American Al Jazeera media, don't interview Trump live. Listen to this. He's on Mediaite's Press Club. What the hell is Mediaite's Press Club, mister? Is that a podcast? A video podcast over there at Mediocreite. So do the little prepubescents working at Mediocreite, do they actually have to do these interviews with their pants on? I know Jeffrey Toobin is a big hero of theirs. They probably have portraits of him from that Zoom hanging in their offices. Let's take a listen, shall we? Cut 9, go.
He'll be up on a town hall stage or a debate stage or in an interview with a reporter, and he'll say 2 + 2 = 5, and we'll get fact checked. And we'll. So
this is Mediaite, you see. This is the Dan Abrams outfit. Dan Abrams, who is the Jerry Springer of cable TV and Law and Order and courtrooms and all the rest. That guy who uses crazy glue to put his hair on every day. That guy who pretends he's a journalist. That guy. This is his operation. He wears many hats or toupees or whatever he's wearing. So there he is, Aidan McLaughlin. Mediaite, like they're the moderators or for the media, you know. Now these guys, all they do is they steal the content from everybody else, right, Mr. Bidou? A clip here or something like that, and twist it and put a headline on it. And typically it's anti-Trump. Typically it's anti-Israel. Typically it's the usual fare. Now that Media Matters looks like it's going out of business, Mediaite has decided to follow their business plan. As long as little Danny gets his money. Go ahead.
True. Or when there's a controversy and he doesn't apologize for it, when any other politician in the history of politics would.
But I think, and that means, I mean, it's going to be a challenge for those who are doing the debate in June. I mean, I think it's journalistic malpractice to do a live interview with President Trump on television.
Remember they had little Chuck Todd saying nobody will ever come on this network who disagrees with climate change. We will not have climate deniers. Then we have, he was a Democrat and is. Then we have a little Stephanopoulos, Steffi. It is journalistic malpractice to interview Trump live on TV. And then, of course, we have fake Jake Tapper. We will never run a full Trump event, given all the things that he says are inaccurate. So we basically have a Stalinist, tyrannical, Al Jazeera-like media. You know, we can make our own decisions. Honestly, we can, but they won't allow it. Instead, they'll run with Biden. Look at that. He's actually walking. See, we told you. He's up to the job. Look at that. He finished his sentence. He actually, he does have brain cells that function. Oh, yeah. See that? That Wall Street Journal, those reporters, they're under attack, those reporters. They're not even, quote unquote, concerned. They're under attack for writing that story. They're under attack by other journalists. That is, other frauds. I'll be right back.
Mark Levin.
It's a pleasure to be here with our friend Tim Scott, one of the nicest, most decent people you'll ever meet. Senator, how are you, sir?
Mark, it's always good to be back on the radio with you. I got to say, you're saving America one show at a time, and I love it. Thank you.
You're very kind. Thank you. I mean, you're out there in public. You're speaking. You speak to a lot of media. Is there any doubt, Senator Scott, that if you were a liberal or even a Marxist, a radical bomb thrower, that you would be treated very different by the American media than you're being treated today?
Oh, Mark, absolutely. Here's one fact we all have to realize, and thank God you're on the show, because you continue to reinforce the fact the media is an extension of the liberal elite. They are not just Democrats. They are literally leading the charge in the wrong direction away from. They are antithetical too often to the American dream and what our founders wanted for this country. They don't want free speech. They want to squash free speech. But what they really want, Mark, is for people who look like me, African Americans or Hispanics, women, millennials, they want all of us to sit down, shut up, and vote blue. They don't want us to have a thought that comes from ourselves. They want groupthink to be the only option on the table. They refuse to treat individuals in our demographics. They want to just say all black people think this way, all Hispanics think this way, all women think this way. What they are afraid of is that the American dream can be pursued one American at a time. Because if the dream can be pursued one American at a time, we want 4 more years of Trump. We want 4 more years of liberty. We want 4 more years where my voice matters, not a part of a group, but as an individual. We want 4 more years where we respect the integrity and the sovereignty of our country by having a border that is closed. You see, there are millions of African Americans who are coming to Donald Trump's rescue because of jobs and justice. You see, under Donald Trump, we had 4 years of plummeting unemployment rates. We had 4 years of the strongest growth starting at the bottom of the food chain, not at the top. If Donald Trump didn't care about black or white, red, yellow, he didn't care about colors. He cared about the American people. And anytime I dare to tell the truth, the media, the women on The View lose their minds. In MSNBC and CNN, they lose their minds. It's just disgusting.
It is disgusting. And, I was talking earlier about independent thinkers. I had Byron Donalds on the other day. Stephen A. is a good friend of mine. You. And I'm not just talking about black people, but just people who think for themselves. They see what's going on, and they refuse to go with, quote-unquote, their community or, quote-unquote, their social group or, quote-unquote, the way they're supposed to be. And it's people like that who come under attack. On the other hand, I think you'll agree, Senator, it's also people like that, people like you, who become leaders, and people notice that too, no?
Mark, you're 100% right. One of the things I love about our country, listen, I am an African-American born in the deep South in South Carolina. I was born in Charleston, where the Civil War started, Mark. I understand division. I understand hatred. But I also understand healing. I understand reconciliation. I understand that one of the most important yet very often left behind story It's the story of the American heart and the transformation that's happened in a single lifetime. I understand that when I ran for Congress against the son of Strom Thurmond in an 80% white district, they voted for me based on the content of my character, not the color of my skin. You see, in America, we are hungry, thirsty for leaders who represent our ideals, not our color, not where we're from, but what we believe, Mark. And that is the beauty of America. It's why I fight every single day to make sure that more Americans have a chance to be seen as an individual, heard as an individual. And if we were to stand together, and this is what Donald Trump is doing. He's bringing together this new coalition of working class Americans. He doesn't care whether you're a union worker or a non-union worker. He doesn't care whether you're black or whether you're white, whether you're a male or whether you're a female. Only two genders in the world, by the way. He does not care. He cares that you are a red-blooded American. And if you will work for it, he wants the playing field to be level. He wants the sky to be your limit. He wants hope eternal. But he's willing to say what no one says very often. The patriot Donald Trump says, I would rather it be me in that courtroom instead of you. And Americans rally to freedom and to fairness. And that's what you're seeing. And that's why I believe that absolutely, positively, unequivocally, Americans reward individuality. They love the individual. We respect the person who enters the arena as an underdog. We do our homework, Mark. One of the reasons why we do good homework is because you are on the air, whether it's radio or TV. You do your homework, you educate, and then you motivate and inspire Americans to live up to their fullest potential. That requires us to know our history. It requires us to know the difference between the left and the right, not just what the media sells, but the truth. It's Republicans who in the 1960s stood up for civil rights. It's Republicans in the 1860s that ended slavery. It's Republicans that brought the most money to historically black colleges and universities in the history of the country. It's Republicans that brought the black unemployment rate to the lowest point in history. That Republican, by the way, was Donald Trump. But when we don't worry about the color and just work really hard for results, it benefits all of us. And then we stand together. One nation, under God, indivisible. But right now, with Joe Biden, it is not liberty and justice for all. No! It is targeting your political opponents. But we will have better. November 5th, the day of reckoning. America will stand as one, unified behind Donald Trump. We will have 4 more years of Donald Trump. We're going to fire Merrick Garland. We're going to clean out the DOJ and restore the confidence of the American people.
Thank you, Senator. Very, very inspiring. Be safe and God bless you, my friend. We'll be right back.
Mark Levin, the thunder on the right. Call in now, 877-381-3811.
We have our friend Jack. I think it was from Buffalo, right, Mr. Producer? From yesterday. Jack, how are you today?
I'm good, Mark. How are you?
Good. Okay. You had some questions for me, and I didn't want you or people to think I was cutting you off. It was the end of the show.
We were talking about some things on the Trump trial.
Mm-hmm.
The first one obviously had to do with Ramos versus Louisiana. And then the second one we were getting to...
Well, tell the people what that was about. We started it, but we didn't finish it.
Well, that was a Supreme Court decision, which a lot of people are saying represents that you need to be found guilty by unanimously on all matters in a criminal trial. I don't believe that holding in that Supreme Court case even.
But I'll tell you why you're wrong. That's not this case. This case was the judge gave them 3 crimes to pick from, right? That's not Ramos. That's not even about a majority on a single crime. They could pick one of 3 crimes as long as they all agree on the underlying crime. And the defendant and the defendant's lawyers have no idea what the hell crimes they're talking about. So this is much more convoluted.
Okay.
But let me just say, if the case in Manhattan gets to the Supreme Court, it'll be an issue of a lack of majority, but it'll be worse than that. It'll be, you're honest, we don't know exactly what the jury even voted on. And to this day, we don't know. We don't have a piece of paper that tells us what they found him guilty on of the 3 crime alternatives they were given. You don't get to pick. It's not multiple choice. Anyway, go ahead.
I agree. I mean, you're going to say it's not a smorgasbord, right? Let me
I actually like a smorgasbord myself. But anyway, go ahead.
I could be found guilty in New York State of falsifying business records and also be found not guilty of grand larceny. Is that a contradiction?
No.
It's the same thing.
No. When you're in court, do you know what you're charged with?
You know that you're charged with falsifying.
You have a lawyer. You got a lawyer represents you. A lawyer has to know what you're charged with, so he knows how to defend you. He knows what kind of witnesses to bring, what kind of evidence to bring. And we didn't know till the end, number 1, that there was going to be a smorgasbord, and number 2, what the smorgasbord was going to be, and number 3, the smorgasbord was actually rotten and rancid because the statute of limitations for a smorgasbord had run, and he used a federal law, which they never defined, just the FICA, whatever that means. And so I think you do a great disservice to yourself when you try to persuade yourself that we've ever seen anything like this before. Supreme Court has never ruled on something like this or in favor of something like this. Ramos has nothing to do with it. It has nothing to do when you go to court and you're charged with 2 offenses. You could be found guilty with one but not the other. The judge doesn't say, here's 2 or 3 crimes, jury. Now, you pick the one. If 4 of you go with this one, and 4 of you go with this one, and 4 of you go with this one, that's okay. No, it's not okay.
Oh, well, let me say this: that if you look at those crimes, first of all, I disagree that the Trump defense was not notified of the crimes up until the day of trial.
They weren't.
Judge Merchan.
All right, what was the federal offense? Because without the federal offense, nothing survives. What was the federal offense?
Wrong. Okay, here's what happened.
No. I saw it. I don't need to be informed about what happened. I'm asking you a question. What was the federal election law that was violated? Because without that, you have no case. The whole theory was that you breathe life into these dead misdemeanors, and not only that, you turn them into felonies if you can find that they were predicates to commit another crime. In this case, it was a federal election crime. What was the federal election law? Tell me so I can look it up.
The same law that Michael Cohen pled guilty to.
See, now you're being a sleazeball. Now you're being a sleazeball. Because, are you a lawyer?
I am.
Okay, so when you go into court, Michael Cohen's guilty pleas, even this judge said this, but nonetheless allowed it, have nothing to do with Donald Trump. And if you're a lawyer, you know damn well he pled to those offenses, even though he wasn't guilty of those offenses, because he wanted to get out from under. It has absolutely nothing to do with Donald Trump's innocence. Nothing.
Well,
what's your next point?
What I'm saying, my next point, Mark, is what the jury instruction said was the first thing you looked at was the New York election statute. And if you determined that there were unlawful means to interfere with an election, you then looked to the statute of FICA to determine what
and we only learned that when the jury instructions were given. We only learned about the tax issue, quote unquote, when the jury instructions were given. Now, that's us. If you're a defense lawyer and you're representing somebody, your jaw hits the ground. You're going to see, I'll be proven right, okay? When your jaw hits the ground and it's, excuse me, I didn't even know we had to defend against a tax issue. Excuse me, I didn't even know we were talking about state campaign laws here.
Well,
all right. Anyway, thank you for your call. I've spent enough time on this because we're not really discussing the law, are we, Mr. Producer? I don't like the sleazy stuff. The guy sounds like a very, very nice guy, but he's ideological about this. I'm not ideological about this. I'm not. So when the gentleman is using CNN and MSNBC talking points and the big giveaway was when he said, well, Michael Cohen pled guilty to campaign violations, then you know he's just spinning. And I don't have time for that. Neither do you. You want to discuss the law? Let's discuss the law. You want to discuss notice and due process? Let's discuss notice and due process. You want to discuss the Supreme Court case in Ramos? Let's discuss it. Because when you do discuss it, it becomes apparent, black and white, what took place in that courtroom. But if you're going to spin, well, Michael Cohen pled guilty, so what? Donald Trump didn't plead guilty, and that has no relevance in that courtroom where Donald Trump is. None. Zero. Really. So let's go back to that montage that goes on and on and on with the media and intelligence officials saying that the laptop was Russian, created by the Russians, Russian psyops. They all knew it was a lie, but they did it anyway because they're going to do it again and again and again. Go ahead, Mr. Producer.
We're being told by two people who have been briefed on what the FBI is doing is that they're looking into whether these unverified emails about Hunter Biden published by the New York Post about foreign business dealings are part of the bigger Russian disinformation effort, which is well underway.
No, they're part of the media Biden Democrat disinformation effort, which we, the American people, have to deal with every minute of every hour of every damn day. Go ahead.
20 race. The intelligence community has said for months that Russia is very actively engaged in a disinformation campaign in the 2020 election, in particular against Joe Biden, to denigrate his campaign in favor of
We have the
President
Russia collusion hoax. We have the laptop hoax. That is the hoax that the laptop was a Russian plot. We get so much disinformation and misinformation, a.k.a. propaganda and flat-out lies from the America Al Jazeera. It's just unfriggin' believable. Go ahead.
A lot of issues related to this New York Post story that reportedly referenced Hunter Biden emails. And as I and several of my former colleagues have pointed out publicly, that it does bear the hallmarks of Russian disinformation.
Intel Committee Chair Adam Schiff, who said this discussion over Hunter Biden and the story that came out in the New York Post that is highly questionable and dubiously sourced is part of a Russian disinformation campaign.
Well, what I can tell you for sure is that Rudy Giuliani was the source of this hard drive and this information for the New York Post story. Also, the intelligence community has been saying repeatedly that
whether it's a laptop or flags or a Coke can or an accusation about Jim Crow against a black congressman, this is what they do. This is a sleazy character assassination operation that is destroying our country. This is a Stalinist media for a Stalinist party. I'll be right back.
Mark Levin.
Folks, please set your DVR for tomorrow night, whatever time zone you're in, Eastern. It's 8 p.m. Eastern time on Fox, Life, Liberty, and Levin. We have a tremendous show on Saturday with Elise Stefanik and one of the great professors, Stephen Calabrese, who is involved, in addition with Landmark Legal Foundation, in challenging the constitutionality of Jack Smith's appointment. And Sunday, another killer show. Again, please set your DVR. It doesn't hurt. Just set it permanently in case you're not home. You can just flick it on. And we have America's governor, Governor Ron DeSantis. He's fantastic. And America's wise man, Victor Davis Hanson. Just wonderful. And we'll go through all these issues together. Substantive, smart, long-form interviews. Not a rush. Not a comedy show. We have fun. We entertain. But we seek to be relevant and important so you're not wasting your time on Saturday night or Sunday night. This is how a lot of people like to top off their Sunday night, the end of the day, by watching Life, Liberty, and Levin on Fox at 8 p.m. Eastern Time. So set your DVRs. That's what my wife does just in case we go to America every Friday in honor of you. Here we go. Folks, the week is officially over. The weekend begins right now. Please set your DVRs, Life, Liberty, and Levin, Saturday and Sunday, 8 p.m. Eastern Time, or whatever time zone you're in. We salute our armed forces, police officers, firefighters, emergency personnel, our truckers, and, of course, our brothers and sisters in Ukraine and Israel. We have your back, Israel, even though Biden does not. Good night, Spritey and Griffey. Good night, Pepsi and Smokey. Good night, Zelda and Gigi. Good night, Indy and Patton and Rory. Good night, Barney. Good night, Marty. Good night, Dad and Mom. Good night, Leo and Joe. Good night, Teddy. Good night, Lou. And the list goes on. And America, good night to you. I'll see you tomorrow on Fox, 8 p.m. Eastern. Have a fantastic weekend, and we shall overcome. God bless you.